Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Live Law. We bring to you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with the update from the Supreme Court. The Supreme Court today dismissed the election petition filed in the Madras High Court challenging the election of DMK MP Kanimozhi in the 2019 Lok Sabha general elections. The context here is that a petition filed by a voter, A. Sanant Kumar, challenged her election, raising grievance that in her affidavit disclosing assets, Kanimozhi had not mentioned her husband's PAN details. Kanimozhi sought dismissal of the election petition, which was refused by the Madras High Court. She then approached the Supreme Court, which stayed the proceedings before the Madras High Court. In this case, the main issue before the Supreme Court was, should a candidate standing for elections reveal the PAN details of their foreign spouse? Kanimozhi's husband is a citizen of Singapore. Advocate P. Wilson, appearing on her behalf, had informed the court that she had clearly mentioned that her spouse did not have a PAN number. She had marked not applicable against the column in the election nomination form, which asked for her spouse's PAN card information. The parties had concluded their submissions last month and the bench reserved its judgment on April 26th. Finally, the Supreme Court bench of Justices Ajay Rastogi and Bela Trivedi today allowed the appeal and upheld her election. The Supreme Court today again refused to entertain a plea against the controversial movie The Kerala Story. Senior advocate Huzaifa Ahmadi mentioned the matter before the CJI, saying that the Kerala High Court had refused to constitute a bench today to hear the matter. This was despite the Supreme Court yesterday allowing the petitioners to seek urgent hearing before the scheduled date of release of the film, that is May 5th. CJI Chandrachud also observed that a deliberate urgency had been created as the petitioner did not avail the proper remedy at the right time. They initially sought to challenge the certificate in an interlocutory application in a pending hate speech case, which was turned down by another bench. The CJI observed, and I quote, "You must be very careful about staying films. The market will decide if it is not up to the mark." Another update on the same issue is that Madras High Court also dismissed a public interest litigation today filed by a Chennai-based journalist seeking ban on the release of the movie. The vacation bench of Madras High Court dismissed the PIL after observing that the Kerala High Court and the Supreme Court had already dealt with the issue and that petitioners could not assume that the movie would create law and order problems without watching it. The Supreme Court today closed the petition filed by 3 women wrestlers against Wrestling Federation of India President Brij Bhushan Sharan Singh over alleged sexual harassment. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardewala noted that the petition was filed seeking FIR, and now that the same had been registered, the purpose had been served. The bench granted liberty to the petitioners to approach the jurisdictional magistrate or invoke the remedy under Section 482 CRPC before the Delhi High Court in case of any further grievances. Also, the petitioner's lawyer, Senior Advocate Narendra Hooda, today requested the bench to monitor the investigation, considering that Delhi police had refused to take action till the Supreme Court's intervention. However, the bench turned down his plea and said that it has given liberty to petitioners to invoke other remedies. In another important development, Supreme Court today set aside an order by a magistrate in Kolkata directing a police investigation into an allegation of rape and criminal intimidation against BJP National General Secretary Kailash Vijayvargiya, RSS member Jishnu Basu and suspended BJP leader Pradeep Joshi. Vijayvargiya has been accused by the prosecutrix of rape, and she alleged that the accused had threatened to kill her and her son and was also physically assaulted on multiple occasions. Regarding the same, 2 complaints were lodged in December 2019, but no FIR was registered. So an application under Section 156(3) of CRPC was filed, which was dismissed by the Chief Judicial Magistrate Alipur. This order was challenged before the High Court, which set aside the order of the magistrate and remanded the matter back for consideration. Then in October 2021, on the basis of the directions passed by the Calcutta High Court, the magistrate directed the complaint to be treated as FIR. Special leave petitions were filed by the accused against the Calcutta High Court decision. And in December 2021, the Supreme Court had reserved its verdict on the same. Today, almost 17 months later, the bench of Justices M.R. Shah and Sanjeev Khanna quashed the magistrate's order which directed the police investigation, and the Apex Court also directed the magistrate to consider afresh an application to register FIRs against the accused. To read the full story, you can click on the link given below. In another important development, the Supreme Court today issued notice in bail pleas filed by Jyoti, Jagtap and Professor Shoma Sen, accused in the Bhima Koregaon Elgar Parishad case under the anti-terror law, the UAPA. Jagtap was arrested by the NIA in September 2020. And on the other hand, Shoma Sen, who is an English literature professor, was arrested in June 2018. She, along with 5 co-accused, was denied bail by Pune Sessions Court in November 2019. Today, the Supreme Court bench comprising Justice Aniruddha Bose and Justice Sudhanshu Dholiya issued notice in both the special leave petitions. It is almost 5 years since caste-based violence broke out at Bhima Koregaon in Pune on 1st January 2018 on the day of the bicentenary celebrations of the Bhima Koregaon battle. Police investigation into the incident led to the arrest of several activists who allegedly had Maoist links. The police alleged that they funded the Elgar Parishad meeting on 31st December 2017, where inflammatory speeches were made leading to the violence. For more updates on the matter, stay tuned with Live Law. And now an update in the matter relating to the infringement of freedom of movement of the Mao community of Manipur. The blockade of NH39 in southern Nagaland had been imposed since December 15 last year by the Southern Angami Public Organization SAPO on settlement, residency, trade and commerce and movement of Mao tribe members through Southern Angami tribe settlement areas in Nagaland. Against the same, a PIL had been moved before the Supreme Court and was being heard by a bench comprising CJI Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala. Solicitor General Tushar Mehta today informed the Supreme Court that as per his instructions, the issue had been resolved. The blockades had been withdrawn and there was no hindrance of movement anymore. So the bench disposed of the petitions and granted liberty to the petitioners to move the Manipur High Court in case of any further issue arose. The Supreme Court today refused to entertain a PIL challenging Section 62(5) of the Representation of the People's Act and seeking the right to vote for prisoners. This section provides that no person shall vote at any election if he is confined in a prison or is in the lawful custody of the police. The court today noted that the section had already been upheld by the Supreme Court on 2 separate occasions. In view of the same, the bench comprising CJI Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala expressed its disinclination towards entertaining the petition. Chief Justice of India D.Y. Chandrachud today orally remarked that he was taking administrative actions to ensure access to hybrid hearings in various high courts. The remark came upon a mentioning made by Advocate Siddharth Gupta concerning hybrid hearings. He informed the bench that despite the COVID cases being on a rise, many high courts were not permitting hybrid hearings. In February this year, while hearing petitions seeking hybrid hearings in the high courts, the CJI had made certain strong remarks criticizing high court chief justices who are shutting down virtual courts option. Coming to another news from the Supreme Court. A petition was filed by an indigenous cattle conservationist and the founder of a Gaushala seeking a declaration that the action of promoting and encouraging artificial insemination of nondescript cows using semen from exotic foreign breeds was arbitrary and against Article 48 of the Constitution. Further, he sought directions to centre and states to take appropriate steps for educating the farmers and livestock owners of the benefits of indigenous cattle and the long-term harmful effects of rearing exotic or crossbred cattle. The petition argues that over the past few decades, India's single-minded pursuit of increasing milk production has resulted in a steady decline in the population of its indigenous breeds. The Supreme Court remarked that an appropriate remedy would be approaching the competent government department. Accordingly, the bench comprising CJI DY Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardewala directed the petitioner to make a representation to the Department of Animal Husbandry. And lastly, coming to an update from the Patna High Court. Today, while hearing a plea challenging the Bihar government's decision to conduct a caste-based census in the state, the Patna High Court in an interim order stayed the census. The Bihar government launched the caste survey on January 7th this year. The plan is to compile data on each family digitally through a mobile application in the survey from the panchayat to the district level. The petition filed against it argues that the subject of the census falls in List 1 of the 7th Schedule of the Constitution and only the union government can conduct the census. Today, the Patna High Court prima facie said that the caste-based survey amounts to a census which the state government has no power to carry out as it encroaches upon the legislative power of the Union Parliament. The bench of Chief Justice K. Vinod Chandran and Justice Madhuresh Prasad gave its verdict today and has listed the matter for July 3rd. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.